everybody, it's Lee Caraher, and this is Everything Speaks, where we talk about how everything you do and say speaks for you, if you wanted to or not. And today, I have Sharon Toerek. She's awesome. I'm so excited.
So are you.
Sharon is the founder of Toerek Law, Legal and Creative, or Legal and Creative Toerek Law.
Either way works.
Either way works.
Yeah.
Where she focuses her national law practice on helping professionals in advertising, marketing, creative services industries protect and monetize their intellectual capital and manage the legal implications of their marketing and advertising work. Sharon provides proactive strategic counsel to communications, marketing, advertising, and creative agencies, that's us, on legal and business issues they face continually in their work. And there's a whole long list of them, and we're going to talk about them, so I'm not going through the whole list.
Yeah.
She is approved participate in the 4A's Legal Consultants Panel, big deal, and a past president of the American Ad Federation, Cleveland. She's the publisher of the marketing industry legal blog, Legal and Creative. I read it, do that. And she created the Legal and Creative Agency Protection System, a comprehensive legal education resource and toolkit for marketing, ad, and creative service agencies. She's also the creator and host of The Innovative Agency, a podcast about innovation and trends in the marketing agency world. She's the real deal, people. Sharon, thank you for coming onto the pod.
Thank you, Lee. I'm excited to be here. I'm looking forward to our conversation.
So Sharon and I are in a mutual group with Predictive ROI, which is Stephen Wessner's group, who I've talked about here on the pod before. And she's given several webinars to his community. And I participated in a couple of those last year where Sharon talked, and I was just so impressed. And I was like, I need to have her on the podcast.
Thank you. I'm so glad we made it happen.
So tell me first, when did you start your firm, and what compelled you to start your own firm?
Well, this isn't my first firm, but I started this firm 9 years ago. Hard to believe. And I did it because I wanted to specifically serve independent marketing agencies of all stripes, communications, digital, creative branding. And I'm an IP lawyer by training. Just over the years, started working more and more with marketers and branders, and that led to focusing more and more on working with agencies. It ended up that was sort of how our landscape in Northeast Ohio, where I'm from, was dominated at the time. And so just got very engaged with the agency community. And that sort of led to a pathway of connecting with other business owners who owned agencies, speaking to them, learning about them. And I founded this firm specifically to serve them nationwide. And so we help them with 3 buckets, basically, intellectual property, protection, licensing, contract negotiation and development, and marketing regulation compliance. And so...
so you're busy on number 3 for sure.
Well, yeah, we are, but it's they all interplay with one another.
Absolutely.
In very specific ways. And so what I like about serving a narrow niche deeply is that you can be holistic about it and see how those things all affect each other in the businesses of your clients, which I think would be more challenging to do. Well, which I know is more challenging to do because I've been a partner in a more broadly focused law firm for businesses when you're looking at all industries. So, and I love it. We get to have a front row seat to the creativity that agencies generate every day. I don't think many of my peers see as much of that as I do on a daily basis. And so we love our agency clients. They have peculiarities as business owners that we've learned, we've learned to love.
Okay, wait. Tell me more. Give me a peculiarity that you didn't expect.
Oh gosh, now you're really putting me on the spot, Lee.
I have a few thoughts.
I know, and you and I had this conversation briefly, but many agency owners are accidental entrepreneurs, and so they don't like being proactive, which is the hallmark of what a law firm helps a client do, is to be proactive, ideally. So it's a lot of putting fires out at the last minute. So I think that is a peculiarity. And sometimes I think the adrenaline appeals to certain agency owners. We'd prefer things a little calmer, but
yeah. Well, there is a classic difference between lawyers and agency owners or agency people. I would not necessarily owners, because agency people, we're below the line. We're a little bit at arm's length. We're not necessarily in the fire. And then what happens, particularly in the PR communications thing, right? In that category, something happens at a client and it's like, oh, what? Mm-hmm. And the first thing they do is call the PR firm when they should have called us like 3 months ago or let us know that something was brewing, right? Because if they let us know something is brewing, then we can plan. Right. Yeah. And so we are often, and in general, that's the senior people on the team. And if you have a small agency under 40 people, you're going to get the CEO or somebody in the, founder group involved. And that's where people are the happiest, frankly. If you're a founder, and you have an agency of 20, 30 people, the most valuable you can be is in a crisis, right? Mm-hmm. Or in the startup. So, wow, I get to be valuable. I wish it wasn't like at the freaking last second, but there is juice there, right? Yeah. So if that person has moved over to a ownership and entrepreneurial side, and they're used to getting the cortisol or whatever the hell it is that, from that thing, I can imagine that that's an issue.
Well, yeah, I mean, as a class of entrepreneur, agency owners don't mind flying a little closer to the sun, generally, in our experience. And they also
they may not make the best decisions.
Agencies are hardwired, in my view, based on the hundreds that I've worked with. They're hardwired to create the top line results for their client and by extension for their agency. Now, whether that top line result is a particular brand impression out in the world or whether it's actual revenue, it depends on the goals, right, that you've established. But so they're not so in love with the foundational things and slowing down enough to put those in place that would make their lives a little bit easier in the long run. And they're not particularly fans of legal fees. I mean, I don't suppose any business owner is, but there's a sensitivity there to not really engaging legal from a process perspective or from a financial perspective until you absolutely have to.
Can I just interrupt?
We work hard against.
So agency leaders out there, and I've talked to many of you, people who want to be their own agency, people who want to start their own consultancies. I've probably helped, over 30 people do this.
Yeah.
And that's the first thing I always say to people. One, get someone, an accountant, because in general, agency people are not great numbers people. And if you're good at the practice of what you're doing, unless it's finance, you're not good at that. And then two, get your lawyer first. Because when you get these two things, these things are things that you're not good at. You're going to need to put your time where you're the most valuable in an agency. And if you can get your legal and your financial support first, pay them before you pay yourself. Yep. Because this sets the foundation of how you will set up your agency so that you can focus on what you are good at, as opposed to what you just said earlier, being the fireman or the fire person with the hose. And it'll end up costing you less over time.
Absolutely. That was what I was going to jump in with. The savings of time and money.
Oh, exponential.
Yeah. And it doesn't really take you that long to recover it either.
No, it doesn't. Yeah. So that is so funny. It's also funny, because one of the biggest things that agencies have is like, why should we pay you for that service? Well, then we need to take that feeling that we have when someone says, why are you worth that much? And transfer it to all the other services that we employ to do our own work. So that just drives me nuts that is sometimes true for you. And hey, if you're listening, don't do that.
I think it can help. Yeah, I agree. But I think it can help to think of the concept of amortization, right? Just like most of us don't pay for our houses or our buildings in cash at once because we probably don't have it sitting there. And also it wouldn't be smart because there's other uses for those resources. Think of the amortization of investing in good, strong legal foundation and process and documents and all the rest of it. and extend that through the life of the number of clients you sign up in a year, for example, or the number of contractors you sign up to work with you and your agency, et cetera, et cetera. And when you average out the cost per deal, the cost per situation of having, it's a more rational way of looking at what it's really costing the agency.
Well, I think I shared with you a number before we started the podcast. So I got those services before I started my agency, or when I didn't pay myself, but I paid everybody else, including the lawyer and the accountant person, blah, blah, blah.
It wasn't me, but thank you.
It wasn't you, because you weren't in business then, because my business was 22 years old and you didn't have this firm.
No, however, thank you for paying your lawyer first. I'm sure they appreciated it.
And I've stayed with that person. Well, the first person I had, she said, "You're getting too large for me. I can't deal." So then I got another one probably 3 years in, and I've been with that person through 2 firms. And she knows my business. She picks up my phone call. Yeah. I talk to her maybe twice a year maximum. And she's like, done. And I just pay the fee because it's over. However, so the first thing we did was set up a contract. And we've changed our contract a couple of times over the course of the agency because it's 22 years old and that's what you should do. Laws change. But in 22 years, I've only had one client not honor the contract that they signed. And it's still pissing me off because it happened 2 months ago. And when I told you this, you were like, really? So I think it's extraordinary that one person would do this. Like, what is going on that you would not honor your contract when we have demonstrated our value 1 million times over? And your reaction was like, you're pretty lucky. So tell me more about that.
Well, look, I think part of this is, the reality is over the last 18 months or so. So we had during the pandemic, some agencies really knocked it out of the park, but a lot of agencies really struggled depending on the vertical they were serving or just how they were doing business generally. And then they recovered, right? And because we had some awesome boom years right after when things got back more to full speed. Then 2023 is a mixed bag, kind of a meh year for a lot of agencies. Some did really well, but some were kind of concerned, right? And so I think when uncertainties like that occur, clients start thinking about different ways that their fantasies were not realized, the marketing services. No, and I don't,
because they're so amorphous. Well, they're amorphous, and in PR, there are things that you cannot.
It's hard to measure, and some
can't guarantee it.
Marketing, it's hard, right? It's hard to measure.
Cannot guarantee media relations.
So using not being happy with performance as a pretext in some circumstances when there's really something else going on, like perhaps the client's business isn't doing well, or the client was not a good fit for you and they're not acknowledging that or coming to the table in candor and saying, look, your approach isn't a good fit. Whatever it is, I think that's part of it. I honestly also just think that agencies and clients are not always clear upfront with each other about how success is going to be measured.
So let's talk about that.
Yeah, whether that means metrics, whether that means particular metrics of performance, whether that means in your particular discipline, whether that means number of mentions or number of whatever it means, they're not clear up front about what they're expecting. Yeah. Oh, your agency thought you wanted X number of leads. What you really meant was, client, you needed a bump in gross revenue of X percent. So you needed X many more customers or
conversions.
Clients. Yeah. We didn't understand that. Right. I would argue you should have understood it as an agency, but okay, we didn't understand that. And so we're measuring different things. That's a lot of it too. And, most of it should be reflected in the documents that you present to as partners.
Let's talk about I believe, so 22 years, only one person not, and it was an individual entrepreneur, not honoring the contract. And I have not signed contracts if the client wanted 2 clauses taken out of their contract, which I'll talk about in a second. Because my assumption is that you love each other at the beginning,
Right.
I'm so excited to work with you. It's going to be fabulous. Day two, you can hit a bump in the road, right? And you should have a contract that basically articulates the relationship and how you end it, like a prenup. And that is what has helped us, ferret out those people who are not going to be good fits, like, from a not an ethical point of view, but from a, they're not going to be a good fit because they're not going to agree to these two clauses. And then then you're not a fit for us. Mm-hmm. And they also get really specific about what is the work. And in our world, our work changes all the time because in the public relations world, communications, all that stuff, we can't guarantee anything unless people pay for it, meaning they pay for the placement. So a lot of the terms change over the course of a month, over a course of a quarter, over a course of a year. So how do you accommodate what happens in the world and how a client needs to react to it in a contract? And then how do you, the other terms are when you're going to pay us, how much you're going to pay us, and what's the penalty if you pay us late, right? So, and if you can get all those things done, one, in the negotiation, you find out a lot about the client.
Right. I agree.
If they just sign it, I don't like someone who just signs it. It says they didn't take it seriously. Mm-hmm. But you find out a lot about the client in that thing. And then two, you get to set up the terms. Like they get to say too, okay, so if you don't do what we want to do, we want you to do, what are we going to do, kind of stuff. Mm-hmm. So in you're thinking about how to set up a client contract before you start work, which is what I tell everybody, do not start any work before you have a contract.
Absolutely.
What do you tell your clients how to set up a client? What are the key phrases or what are the key clauses that are the ones that become the most important ones, linchpins when things go bad?
Right. Well, first, just as a drafting principle, I think whenever it's possible, it's smarter to actually create your statement of work before you finalize the master service agreement. And the reason for that is because many times there are provisions in either your agency master services agreement, or if you're working off paper that the client has presented because that's their requirement and you've decided that you're going to do that. Some of those provisions that are standard are just not going to be relevant. If you're doing a branding project, then data privacy compliance is probably not going to be an issue. So we don't need to negotiate it. If you are doing, if you're not creating any IP, but you're just doing branding work, media work, then, some of those clauses might not be as relevant. So, you've got your 3Ds, your dollars, your deadlines, your deliverables. That stuff should go. That stuff should go in your statement of work. So you should really work on all of that.
I'm sorry, your dollars,
deadlines,
and deliverables.
Deliverables.
I love it. I'm stealing it.
Those are your
Just
3Ds.
going to tell you right now.
Your 3Ds. Put those 3Ds go in the statement of work, in my view, and that'll get you thinking through, like, what are some of the other implications here we need to think about? Like, are we going to be buying third-party services like media okay, so that's going to implicate the payment provisions, right, in our contract. Are we going to be engaging an event team because we're doing experiential marketing? Okay, that's going to have implications for liability, perhaps. So think through the actual scope of work so that you are sure that the terms of your master service agreement account for the actual work you're going to be doing. So that's the first thing. The second thing is my non-negotiables for agencies are intellectual property ownership and transfer. Agencies need to be retaining any of their pre-existing or their foundational IP. And only licensing it to the client, not granting it to them as a work for hire. And you need to make sure that's clear because clients will not understand it all the time. Obviously, liability and indemnification are critical. Relatedly, what are the insurance requirements that the client is seeking from the agency? And do those align with what the agency's policies actually say? And then increasingly, and this is sort of the double-edged sword of owning a niche really well, is exclusivity requests, because we're seeing many more asks. A lot of agencies call this non-compete. It's really not a non-compete. It's an exclusivity clause wherein the client wants you to be married either to them or to a category just for them, something like that. So those are kind of those are my low-hanging fruit, which if you don't get those right, then the rest of the contract really doesn't matter.
Doesn't matter.
Then you've got your second layer of things, that you need to work out, like dormancy fees, payment policies, all the other stuff. So that's kind of the order in which we assess. And, but it starts with what's the work we're actually going to do and what is the measurement by which everybody's going to evaluate that this is working, that it's successful. Yeah.
How do you, so for PR firms often, we offer a wide range of services. Anything that a CCO or a VP of comms or a VP of PR would do, we do. And half of us have been inside, so we know the really wide range of that work, right?
Right.
So we might be engaged in one thing first, and then all of a sudden, after 6 months, we're doing this project and that project and this project. So when you have your master services agreement, should you be anticipating growth of services or not?
You should be. And the way you handle that, in my view, with your documents is by making them modular, right?
Yeah.
The SOW is an exhibit to, not baked into necessarily the MSA. They refer back to each other. But when there's a scope change, whether it's an addition or a subtraction or an entirely new service you're going to be providing them,
new addendum.
Yeah, new addendum, incorporate the master terms into the addendum, and everybody signs off. And, if there's anything that's going to be dropped, you can catch that in the new addendum too with the SOW. Some agencies who have multi-annual arrangements with their clients, they look at this annually. Sometimes if you're going from project to project with a client who's a long-term client, but you only do projects one at a time, it's going to be more frequent than that. It just depends on what your working relationship is with them.
Great. One of the things that clarity, I think I told my word this year, every year I have a word. This year it's clarity.
I love it.
And we're going to be talking about clarity a lot, people, so get used to it. And the thing about the contract is it should provide clarity on those, you call them 3Ds, dollars, deadlines, and deliverables, on all those things. And there should not be room for interpretation, right? And everyone should have the same lexicon. Oh, I meant this. I didn't mean that, or that kind of thing. And comma placement. I'm a big fan of the Oxford comma. Comma placement matters in contracts, but the clarity, just spend the time, because I'm sure you've seen this where you've evaluated a client's former contract. You go, oh my gosh, you could drive a Mack truck through here. Yeah. And if you can drive a Mack truck through your agreement, you will get screwed. Is that fair?
It depends.
If they want to, the client wants to, they will.
You have more issues to defend, I would say, in those circumstances. What I like to discourage agency owners from is focusing too much on what they feel like is the intimidation factor. We don't want an agreement that's any longer than X pages because we don't want to look like we're hard to do business with. Or we don't want an agreement that's got any legalese in it because we don't think our clients are going to want to read that or understand it, and we need to sign them up, yesterday. And my view is the agreement should be as long as it needs to be to have everything in it.
A real business, you will not be the first you're not going to be for the first contract that a client has.
Yeah.
Ever. In this business, you aren't.
Don't underestimate the client and their willingness to do the work of the due diligence involved in reading the contract. They want to do business with you just as much as you do with them in the beginning. And so you should sit down and think through with your counsel what's important to us and what are hills we're willing to die on, what are the nice to haves, and what are the we'd like to have, but they're not critical for us. So you should have an understanding, and that can change from deal to deal. You may want this client's business so badly, either because of the size of the deal or they're a feather in your cap, depending on the industries that you serve, whatever the reason.
We call those strategic clients.
Yeah, strategic. You may have a more flexible viewpoint on IP transfer, which in my view should never happen until you're paid. You may have a more flexible view about that. I'm okay with that if that's your business decision, but actually sit down and think it through. Don't think it's rote and don't think it's predetermined, and don't leave it unaddressed, because leaving it unaddressed is probably not going to end well for you if you don't have an agreement, if you don't have a common understanding with the client about what something means.
One thing that comes up a lot in PR contracts, they end up, I need the media list. And some agencies like, I'm never going to share my media list with you. And in California, I don't know if this is still true, but in California, it is that if you've done the work and they've paid for it, you need to give them the product. And a media list is a deliverable that is tailored to every client. And I don't care. I mean, I'm just like, sure, you can have the media list, because it is worthless as soon as it leaves us. It's worthless to that client.
Yeah.
Right. Other agencies are, they fight tooth and nail on the media list, which, yes, it starts with your own assets because you have it in a database. I'm not giving you my whole database, but it is a product that the client requires for you to do their work. What's your thought on that?
I think to the extent that the agency functions in a very narrow client niche, and just pulling an example out of my brain, let's say you serve tech companies and you are very well connected as an agency to the Silicon Valley media machine, right? The key bloggers, the key columnists, the key journalists who cover that. Maybe because you're using those sources for multiple clients in your portfolio, maybe that is your trade secret, and maybe I would counsel you not to share it.
All discoverable, though. I would tell you that a media list is public because by definition, they're people who are publishing, right? And it could be a newsletter.
If your client knows where you've made a placement and they see the byline, it's not going to be hard to put two and two together. So if it's publicly available, then it's probably not your trade secret.
I don't think a media list is a trade secret. It could be, the trade secret could be, don't call Joe on Thursdays because that's when he's in yoga and he doesn't want to talk to anybody. We're not going to give anybody that information because that information is our own information. But the name and the publication and here's their email, fine, you can have it because it is discoverable. And it's not worth arguing about. The money, the time it takes to argue about something that is findable, we're not going to give you our stuff about Joe. Don't call Joe, only text Joe. Don't do it on Thursdays, it's yoga. We're not going to tell you any of that stuff.
Just be clear with your client about what you do and don't provide. You know, names, email addresses, publications. That's it.
Yeah. I mean, I've had, Lee, you're crazy. You're crazy. I'm like, how much time did you spend arguing with a client about what they owed you and what they had paid for? How much? Well, we had to get our law firm involved. And did you end up giving them the list because you're in California? Yes. I'm like, why are you spending time on this?
Well, there's not a complete universality in the way that agency owners look at this kind of stuff. I mean, there's still plenty, I'm sad to say, because I have a personal bias against this as an IP lawyer, there's still plenty of agency owners who are willing to do spec work as table stakes. Okay, that's a business decision to make. I wouldn't advise it, but if you made a calculated decision that you are going to make that investment so that you can get the audience to possibly get a deal that's very important to you for whatever reason, okay, just understand that you're sinking that cost.
Yeah. And that's more true, not so much in advertising firms. I mean, in advertising firms in general, if they're asking
for a creative firm issue,
a creative firm issue, agency.
Example.
Oh yeah, PR firm. Why don't you do in this scenario? I'm like, no. That's a $50,000 project.
Yeah.
Which we would give you if you paid us. So we're not going to go through that scenario. No one wins in those.
Yeah. Well, and again, every their agency owners will look at it differently. So you're never going to have complete universality
No.
amongst agency owners about their business practices in that regard. And it usually swarms around business development and what you're willing to do, right, to get the client. But just be purposeful and intentional about the decisions that you make, so that your lawyer, when it does come time to paper that deal, understand your goals and your objectives as an agency and helps you protect them.
Clarity, clarity, clarity.
Agreed.
Around dollars, deadlines, and deliverables. I like it. AI, one of the webinars I attended that you hosted with Predictive last year was around AI. And AI, how to incorporate AI in contracts. And, I mean, here we are at the beginning of another summit, right? First it was the web, now it's AI, in terms of what to do. And what is your thought on, maybe it's changed since I attended that webinar, but what is your thought on how to, use AI in an agency, protect yourself from that use, and then B, what do you need to drive into your contracts around AI so that you're protected if a client says, please use AI?
Yeah. Well, I think I can answer the second two questions better than I can speak to the first, which is, I am not an expert on all the ways creatively, strategically, or technologically that agencies can take advantage of particular platforms, to create results for their clients. What I can tell you is that there's three pathways that every agency needs to think about walking down with their client. And that is crucial conversations. And that is with the client and with your team about, does the client have any specific corporate policies around AI usage? Has the client identified any proprietary information that they absolutely do not want us feeding into any AI vehicle because they don't want it part of anybody's training sets, or they don't want it to come out in anybody's output? What's the scope of usage of AI that is acceptable to you as the client? Can we use it for first drafts? Can we use it for research? Can we use it? What is the intended scope of use of AI? And you need to have those conversations with your client up front. So that's, step one. And step two is policies. What is your policy internally around how you're using AI? And it should include the conversations that your account team or your business development people should be having with the prospective client, either at the beginning of a project or the beginning of the relationship when AI is going to be used. You should be asking the client, what data or information are you giving us that you've generated via AI, so that we understand which of this was generative AI created and which is human created? How much human oversight have you done, client, and do you expect us to do as an agency over the work product? Or what's our policy about, the human guardrails that go on the work product before it actually gets publicly released? So it's the conversations and the policies, and then you get to the contract language.
What I find so interesting is that, AI comes onto the scene. AI has been part of our world forever and a day. It's nothing new, right? The fact that Siri can, dictate, give me a transcript is AI, and then can source it. It's just that it's an issue. If we had to do that against all of our platforms that we use, I don't want a client dictating to us which platform to use, unless it's how we're going to communicate with them. If they are in Asana or they are in, I don't care. But if they're going to say, you must use this database service, I'm like, and I just feel, does the AI question then give them a window to saying, oh, we want to look at all of the things that you do to run your business? I'm like, you don't get to say. So is AI about what it generates? That's why it's so important to have a clause around it?
I think the issue with respect to AI in terms of the deliverables that an agency creates for a client is, what are you going to provide to us, the client, or what are you going to publicly release on our behalf that was generated by AI?
I see.
And that's where we want to have an understanding contractually, procedurally, and that needs to be the basis of our conversation and our understanding.
The work product.
Well, yes, the work product and the campaigns, the deliverables associated with the work product. What you do as an agency to run your business on the back end is proprietary to you, and I don't think
there's a lot of AI in that, right? You can use AI to take notes. You can use AI. I mean, there's a lot of things you could do on the back end.
Of course. And those are just business tools that are
so really used. Talking about work product and the campaign, whatever the deliverable is versus the process of running your firm.
Yeah, the legal issues in using generative AI to create the work are quite similar from a legal perspective to the issues associated with using a third-party human to create work, whether it's an independent contractor, whether it is a third-party vendor that will, weigh in. Maybe think about the IP issues that are created when you hire a videographer, or when you are sending a freelance writer, or when you are in a strategic alliance with another agency that is going to contribute to the final work product. The IP issues are very similar. You have the added scrutiny, though, of these machines basically taking input and creating output and protecting yourselves on both sides of that equation, because it is a machine. So, yeah.
And I think, do you imagine that we'll have to look at these AI clauses? And how do you create an AI clause in a contract that predicts the future? Or are we going to have to look at every year? We're going to have to look at the AI clause and
I think agencies should be looking at their contracts periodically anyway to make sure they still reflect the way they're doing business. So annually, at a minimum, is best. But yes, I mean, the language that we have created as our standard benchmarks right now to address the use of AI in creating deliverables by agencies for clients, I imagine is going to evolve and will look different 12 months from now than it looks today. Right now it focuses upon what are the representations that we're making to the agencies, what are the representations we're getting from the clients to the agencies, what's our liability and responsibility if there's an inadvertent infringement of some third party's intellectual property with the output. Some of those things will be benchmarks that won't change. Some of them will adjust as utilization adjusts and as the material, the platforms themselves evolve.
Right. Yeah. So it all comes back to clarity, Sharon. Clarity around the work, clarity around the relationship, clarity around the terms, clarity around the 3Ds, which I just learned about: dollars, deadlines, and deliverables, which I'll be saying 1 million times between now and next Friday.
DDD, that's right, 3D.
The 3Ds for clarity. Just going to say it, because the more clear you can be, the better you will deliver.
Yeah.
Right?
Yeah. Yes.
Period. And the more clear you can be at the beginning of a relationship, the better it is. So while it is always exciting, I'm going to sign a new contract, we should get started. Don't do it. It doesn't help the client. It doesn't help you. Drive that clarity into your relationship from the beginning, so you're not constantly fixing it as you go forward.
I think one of the main business reasons for having benchmark templates in your agency for these agreements is they serve as the checklist and the stopgap for whoever's negotiating your deal. If you don't have a standardization and a baseline for what your legal terms look like, or how you construct your statements of work, etc., you're not doing your account team any favor. If you've empowered your account team to get these things signed off on, then you need to be giving them benchmarks. And one way to do that is standardized agreements that have been vetted by agency leadership, and a clear conversation about what are your parameters for deviating from these? Who do you have to talk to? What's the limit on your ability to be flexible here? So, centralization of the documents, centralization of the approvals. Even in a small agency, this is possible. It may be you as the agency owner, right? The buck may stop with you. That's just a part of your responsibility as the entrepreneur who leads the agency. But if you have a team, pick the most appropriate choke point and make. Every agency needs one operationally, and
that'd be me.
You don't,
double forte.
If you don't have
You're
somebody,
looking at her.
Yep. Well, that's the case for most closely held agencies. It is the C-suite, which is either the owner or perhaps the right hand to the owner or whoever's in charge of revenue. And so the fewer cooks you have in that kitchen, the more your deals are going to be predictable and look more like one another.
Yeah.
Even if you're a firm who ends up having to sign a lot of client paper because you work with enterprise brands or government agencies, having a standardized checklist and process for what you will and won't agree to definitely makes it pass the process quicker, less expensive in legal fees, and ends you up with better deals.
So everybody, get some clarity on what matters to you. Get some clarity with your lawyer about what is best practice and where's your line for deviation, because it's never going to always be the same.
Right, I agree.
If you don't have that clarity from the beginning, then it's going to take longer, be more expensive, and it's going to cost you.
Yep.
Usually, right? Not always, but has the opportunity to cost you. And we don't have time. None of us have time. Our clients don't have time. They hired you for a reason. They hired you below the line to get work done.
Right.
So you got to get it done. But get it done with clarity around purpose, clarity around payment, clarity around deadlines, the 3 Ds, and bake as much clarity into that relationship as possible in this agreement that you will do ahead of time. Sharon, I'm going to have you come back and talk about how in other scenarios, so we're talking about how lawyers can be the best friend of PR people, communicators, and agency owners. Now, we're going to have you come back and talk about the fact that often in a crisis or in a situation, PR people and lawyers are battling around what we can say and what we can't say.
Yeah.
So, well, that would be a whole different conversation.
Okay. Yeah, happy to do it. No, look, we're there for you. We love you. We do it with love.
Sharon's firm does quarterly Q&A sessions with agency owners. The next one's in the end of March. Where can people find out about that webinar, Sharon?
We do. We're going to be actually start publishing the date for our Q1 very shortly. I think it's going to be late March 2024. But reach out to me. Actually, I will have you reach out to Kayla, Kayla, at legalandcreative.com.
Great.
You can always find me at Sharon at legalandcreative.com. And we will be publishing the date probably within the next week or so. I can tell you our first 2 sessions this year are going to be about agency to agency partnerships, how to construct them well, how to make sure, and getting your money. We do not do a lot of, or really any collection work for agencies by design, but we certainly help agencies collect their money in various ways, shapes, and forms. And so one of the sessions will be on collecting your money, getting your money, making sure the contract is created and constructed properly to put you in a good position for that. Other creative solutions for working it out when a client doesn't pay, et cetera, et cetera. So Sharon at legalandcreative.com.
Awesome.
Yeah.
We will have all the links to these and all the emails in our show notes page.
Yep.
I'll just say one thing about working with other partner agencies. One, you have to do it. It's very, even the large firms, they're working with other agencies all the time.
That's a fact of life for every
It's a fact of life, number one. Number two, don't go into a relationship with agencies where you are responsible for them unless they run their business well. Just going to tell you that right now. And maybe it's not my first rodeo. Just going to say it.
Yeah.
But you have to find a way to work with other agencies really well. And those agencies who play well with others are the ones who are going to win the most contracts, because that's how companies are getting things done more and more and more. And there's a lot of reasons for that. Yeah. We can talk forever. I'm not going to keep you forever. Thank you so much for being with us. You're going to have all the links to Sharon and her agency and all the other resources that they have in the show notes page. And we'll have her come back later this year, if she's willing, to talk about the relationship between PR and lawyers on the work side.
I'd be happy to do it.
Awesome. All right, everybody. Until next time, I'm Lee Caraher, and this is Everything Speaks.